आगे बढ़िए, आगे बढ़िए। ओके सर, ठीक है, ऑलराइट। तो बंद मत करना उसको, थोड़ा सा खुला रख देना, कुछ अच्छी शायद थोड़ा सा पूरा थोड़ा सा। यस, इतना ऑलराइट। You see, having seen the structure of the Vienna Convention in terms of the general rules and supplementary means of interpretation, there still remain a couple of things which, although formally outside of the structure of the Vienna Convention, nevertheless those points are quite important on the issue of interpretation, both of treaties and of domestic law. Even before the adoption of the Vienna Convention in 1969, international courts and tribunals had been interpreting treaties. Well, that is quite obvious because treaties as a source of international law are much older than its variant in the form of Vienna Convention. And they have often made a distinction between a restrictive and effective interpretation. Now, these two terms, as they have been used by international tribunals, are, you see, distinct and are in opposition to each other. Let me first try and give you the neutral understanding, terminological understanding of these two terms, restrictive and effective. You see, when we adopt these terms, restrictive, it means that it refers to the possibility of more than one plausible interpretation, because restrictive is a relative term. For instance, when you say that something is weak, so you are definitely making a comparison of the thing that you call weak to something that you believe to be stronger than what you have referred. When you say something is good, which means that you certainly know what is bad. So these are relative terms. So when you say something is restrictive, which means that it is used in distinction with something which is expansive. When you say something effective, it means that it is possible to have two plausible interpretations whereby an ineffective interpretation may be given. So, effective is adopted in contradistinction to ineffective. Now, municipal courts, they have not used these two terms, at least literally. But I am not saying that municipal courts have been unaware of the possibility of more than one plausible interpretation, and therefore of the necessity of choosing one of the possible interpretations. Let us see what municipal courts have been doing. Municipal courts have categorized legislation, that is statutes, as penal and remedial, and have accordingly construed them strictly and liberally. Please try and understand, when a legislation is passed by the legislature, it is not labeled as penal or remedial. You have to actually understand it. This is basically an understanding of the judiciary. When human beings are born, when a child is born, he is not labeled as a good or bad, soft nature, hard nature, reserved, liberal. It is basically those who interact with the child, they ultimately have the opinion that this child is very reserved. This child is very, jovial. Similarly, when the legislature passes a law, it doesn't use these kinds of terms. It is simply an act. Whether it is a protection of women against domestic violence act, whether it is a motor vehicles act, whether it is a food adulteration act, whether it is an income tax act, whether it is a companies act, whatever it is. But when it reaches the judiciary and in the course of the application, and more specifically in the context of interpretation, terms of the nature of the statutes have been used. So let us see the first thing that you need to understand it. We have said it in the very first talk that we started with, in lecture 1, that domestic law of interpretation, barring certain exceptions in the world, is a judge-made law, is a judiciary-made law. It is only by way of exceptions that municipal courts, municipal legal systems have a written law of interpretation, which is a minority, which is an exception. The general rule is, it is basically the judges-made law, judiciary-made law. If that is a principal fact, I think it should not be surprising to you that judiciary has also used terms such as penal, such as remedial. These terms are basically used by the judiciary to describe the nature of these statutes, legislation passed by the legislature. Let me give you an instance, and then you will understand more. Indian students, are students from India here, some of you? Yeah. For instance, Indian Penal Code. The word penal is written there, so obviously it is a penal code. It is a penal statute. Let me tell you some of the instances where the word penal is not used, but those statutes are penal. Food and Adulteration Act. Why penal? It is not necessary that the legislature must have adopted the word penal in the name of the statute. Whether a statute is a penal or not, it is basically the consequences that it attaches for its non-compliance. If the statute prescribes for imprisonment, it is a penal statute. There is no doubt. So it is a penal statute. Essential Supplies Act is a penal statute. Why? Because if you believe that there are some traders in Delhi who indulge in hoarding of wheat, onions, because these are essential commodities. And if this particular fact is established, prosecution is ultimately successful, the hoarder may face imprisonment. And therefore, the statute is termed as penal. So it is not necessary that it must be named as penal. It is basically the consequence for its non-compliance. If the consequence results in imprisonment, penal consequences, it is penal. Now, municipal courts have adopted this, that once they describe a statute as penal, then they say that a proper interpretation of a penal statute is strict interpretation. What is a strict interpretation? According to the judiciary, it is, suppose on a reading of the statute, a person has been found guilty of hoarding. Another interpretation if you give, the person may be acquitted. So strict interpretation according to the judiciary of a penal statute is, the person must be set free. He should not be prosecuted. I repeat it so that you should exactly get what I mean by the strict interpretation. There is no concept of strict interpretation unless there is a possibility of two plausible interpretations. It is not that one interpretation is plausible and other interpretation is implausible. Then there is no possibility of choosing. The choice must be real. It is not that one reading is a bad reading, absurd reading. No. It's not that. It means that both two readings are equally possible. Then the question of choosing arises. And if the nature of the statute is penal, the court says lesser punishment should be given. In other words, the statute must be interpreted strictly in favor of the accused. For instance, if by reading a penal particular provision of a statute which allows for punishment, let us see if it says from 6 months to 1 year of imprisonment, and both imprisonments are possible according to the statutes, the courts would ordinarily give 6 months of imprisonment unless the holder has persistently indulged in activities. For instance, last year he was in prison for 1 year, before last year he was in prison for 6 months. This time the court is going to say, well, he should be awarded maximum punishment. So, last year court was also right in awarding 1 year because the statute says 6 months to 3 years. And this year's court is also justified in awarding 3 years. This is basically strict interpretation. So in other words, strict interpretation means, giving the statute its bare minimum consequences. You can't give less than 6 months. Let us try and understand. Why? Because 6 months is the lowest limit. If the judge gives an imprisonment below 6 months, the judge violates this. From 6 months to 3 years, you have a discussion. Both interpretations are plausible. And I'm sure you must have read some of these provisions. From imprisonment up to 3 years. Up to means maximum. Up to means not more than 3 years, but certainly less than 3 years. Less than 3 years, it may be 2.5 years, it may be 2 years, it may be 1.5 years, or it may be any other possibility. Another example of strict interpretation. Income Tax Act, or for that matter, any tax legislation. You know why? I tell you why. The word penal is of a very wide import. It does not always and necessarily mean an imprisonment, a physical confinement, a detriment which results necessarily in the deprivation of individual liberty. In other words, the statute is still considered to be penal if you are asked by a judicial process to suffer a loss of some pecuniary benefits. For instance, if you are asked to pay 20,000 rupees as compensation, it is also penal. Why? Because the liability nature changes. In one case, the liability nature is the loss of individual liberty. In another case, the liability nature is the loss of monetary gain. So you are losing financially. It is penal. So sometimes when you see the statutes actually allow for punishment either in terms of monetary detriment or loss of individual liberty by way of imprisonment, and sometimes both. You have to pay, you see, some amount as compensation and also undergo for a certain period an imprisonment. In both the cases, the statutes which provide for either kind of detriment as a matter of punishment is considered as penal. So this is one example. In other words, we have several examples in the municipal legal systems of interpretation where penal statutes were described by judges, and they have included not only those statutes which would allow for imprisonment, but also for those which would result in fiscal detriment, fiscal liability. A fiscal liability awarding statute has been considered as penal.
Sir?
Yes.
What about the provisions related to suspension? Like we have departmental inquiry. Should they be considered as strict? Should they be given restrictive interpretation?
Yes,
because suspension is not considered to be a penal act. It's not considered to be a punishment.
Is a very good question that you have asked. A brilliant question that you have asked. And it requires a lot of explaining. Suspension is of three kinds. There are three kinds of suspension. Suspension, one suspension that we have described, which is not a penalty. Another suspension, which is again not a penalty, is suspension pending inquiry. There is a third suspension, which is suspension as punishment. Now I should tell you the examples of both these. Suspension which is not a punishment is, for whatever reasons, the government does not require the services of that person for some period. That person is placed under suspension. You are an employee of the government, and the government will simply say, we don't require your services for some time. That's it. Example, for instance, there are several employees, and I should give you a very simple example because I frequently travel by train. For certain period, certain trains are cancelled. Why? Due to fog. So all these employees, if they are permanent employees, certainly they will not be on duty, but the people who are on contractual basis, they will be under suspension because they won't get any pay. Trains are not running, they are employed as contractual for daily basis. What do you do? Then wait. From 31st of December up to 15th of February, you can see the newspaper. That's a recent and a very current example. Every year this happens. This is obviously not a punishment. Another example. The train has met with an accident. The cause of the accident is not known, but it is certainly true that only two persons are responsible for the actual running of the train, guard and driver. If preliminarily it is clear that either of them is not involved. For instance, if the facts would show clearly that the guard is not involved, well, it is also not proof that driver is involved. So what the government is going to do, government is going to place the driver under suspension pending inquiry. That is again not a punishment. Why? It is not given as if the driver is responsible, but to not allow driver to continue to drive the train because he was involved in an accident. So it is to be proved whether he was responsible, and if he had been found to be negligent, then he should not be allowed to drive the train. In other words, in the second category, there will certainly be a suspension is necessarily followed by a charge sheet. Because no inquiry can be conducted under service law without the charged employee, without the suspended employee being met with a charge sheet. Charge sheet is one. Every allegation is not a charge sheet. That you also understand in the service law. Whether or not a live document is a charge sheet. How do you know? They may give you certain things in writing and say you receive it. Will that be a charge sheet? No. For charge sheet, there are certain legal conditions. Then only it is considered to be a charge sheet. First, there must be specific allegations. A specific word is a critical word. Let me give you an instance. For instance, if a student says that another student has misbehaved, this is the allegation. This is not a specific allegation. Another allegation which is not a specific allegation. He has abused me. This is not a specific allegation. You know why? I should give you an example. You have to say in the first instance, you say he has misbehaved me. You have to quote the behavior. And it is for the law to determine whether it is a misbehavior. What did he do? You can't be judgmental that it is a misbehavior. Similarly, he has abused you. You have to say, what did he say? It is for the law to determine that it is an abuse. That is called specific allegation. For instance, a specific allegation, a person said to you, you people belong to a very low category of people. You have no sense how to behave in the class. You don't have no sense how to eat in the mess. Unquote. So X said this to Y, inverted commas. This is specific allegation. Another, people belong to low category of caste, inverted commas. So this is called specific allegation. First, there must be a specific allegation. Second, the allegation must have been defined as misbehavior or misconduct or an abuse under the law in force at the time when the charge sheet has been served. For instance, there is an act, which the government of India has passed, protection of scheduled caste and scheduled tribes. So if you say that as a person belongs to a lower caste which is bad caste, something like this, it is defined as misconduct, as misbehavior or ill treatment of certain. So that law is enforced. Third requirement, there must be evidence of the specific allegation, either in the form of a documentary evidence or in the form of witnesses. So when you make this,
There should be evidence in the charge sheet. They have to give the evidence in the charge sheet.
yes, you have
After the
to.
preliminary.
No. What you do is basically preliminary inquiry is not necessary. It is not necessary as part of disciplinary proceedings. Any proceeding that is before the service of charge sheet is not considered to be a disciplinary proceedings under the law. In other words, the law is very clear. Disciplinary proceedings are deemed in law to have been initiated, even if not termed as such, with the service of the charge sheet. So anything that you have done before that, fact-finding committee or whatever preliminary, all these things, they have no sanctity in law as such. But the moment you have served the charge sheet, and charge sheet is a proper charge sheet must contain evidence. For instance, you say that he said all these things in front of Mr. So and so. So, the government, if the charge sheet is to be made, the name of that person as a witness must be listed in the charge sheet. Well, of course, the person against whom the person has been listed as a witness will have a right to cross-examine that person. That is basically the procedure to be followed. But what I am saying is this, a charge sheet which is without a specific allegation, which is without a reference to the law, the specific provision of the law, section such and such, article such and such of whatever law, which defines that specific conduct if proved as misconduct. And third, evidence. It is not a charge sheet. This is liable to be quashed soon after its service. You must, instead of facing the inquiry, you should take this charge sheet and go to the court. And there is no limit of number of cases in which the court, Supreme Court has clarified this. A vague allegation like he has misbehaved me, he has abused me. These are absolutely no allegations. Because this doesn't mean anything. How do you know? How can you say? You must say what did he say. It is for law to say whether it is a misbehavior. For instance, let me give you a very simple instance. If you say a person you in English, and you translate English you into Hindi tu, not tum and aap, you can see the variant. In English, if you say he told me you, the law will say what is this? This is fine. But if you say he said tu, and then you add tu itself is not a decent word. In Hindi, it is the lowest form of address, and which is not a decent, acceptable form of address. There is no doubt about it. Tu is a certainly derogatory address. Tum is a friendly, and aap, of course, is respectable and formal. Up to tum, you may defend up to tum, but below that, no. That is what we are saying. So, evidence must say whether it is tu, tum, or aap. It is for the law to determine whether it is derogatory or not. That is why it is said specific allegation. In other words, actual words used. Actual words used. You can't. This is a judgment that it is misbehavior. No. You can't do this. So in other words, these are three kinds of punishments for suspensions. First two categories. The third punishment is, which is a suspension, which is a punishment is, once a departmental inquiry is completed, an employee is found to be guilty of certain charges, and then the question of giving punishment arises. Then only the disciplinary authority determines then how much punishment is to be given. And suppose the disciplinary authority comes to the conclusion that it is a good punishment because there were 6 charges, only 2 were proved, then he should be placed under suspension for 3 more months. And then it should be reinstated. That is a punishment. So, suspension post-inquiry is absolutely, without doubt, a punishment. Absolutely. There is absolutely no doubt about it. So, this is how this is done. Now, absolutely your question, whether a particular conduct rules, service rules and conduct rules are termed as, you see, penal, is a debatable question in the sense that some of the provisions of conduct rules would be treated as penal. Where suspension is to be awarded as a punishment, absolutely it is a penal provision. Post-suspension, post-inquiry is a penal. Suspension before inquiry, before charge sheet, everybody knows that it's too bad, but the law doesn't consider it to be too. Let us come to remedial statute. You must take the best example of remedial statute is, for instance, Maternity Relief Act, for instance. Or a still better example is any procedural law. For instance, Indian students might recall Civil Procedure Code. Civil Procedure Code is a remedial law. Why? Because procedure needs to be followed for the vindication of rights and liabilities of people. So, substantive law, let us say Transfer of Property Act. Very simple question. You are an owner, she is a tenant, there is a dispute. You said, well, I gave this property for 11 months and I want this. You said, well, I won't vacate it. This becomes a problem. Now, the dispute concerns substantive rights. But how do you approach the court? CPC. That is a procedural law. That is called remedial law. So, in other words, any law which provides for remedies for enjoyment of substantive rights is considered a remedial law. WTO dispute settlement understanding, for instance, is a remedial law. Two countries are fighting, one is saying another country, one country says that you are giving subsidies or you have imposed anti-dumping duties, my country is suffering. So how do you do it? How do you say get it rectified? You have to go to the WTO, file a case, and which provision you will invoke? Provisions of dispute settlement understanding. So these are remedial, provide for remedies. Municipal courts have almost, with consensus, have come to the conclusion that remedial statutes have to be given a liberal interpretation. In other words, it should be so interpreted that it is possible for the claimant, for the aggrieved party, for the affected party to be able to vindicate its rights, to be able to get the remedy, even if it results in certain stretching of the strict letter of the remedial law. That is what a liberal interpretation is. So let me summarize the whole discussion. On the international plane, the typical terminology that is used is restrictive and effective. But on municipal plane, I am not aware of this terminology. Municipal plane, I have found n number of examples of penal and remedial characterization. I am not saying that restrictive and penal and effective and remedial, they are, synonymous terms. I am not saying that. But certainly an analogy can be made. There are certain common points. Common points being, in both these sets of cases, courts have allowed the letter of the law to be, in some cases where it is penal, to be strict. In cases where it is remedial, to be liberal. So insofar as in both these circumstances, courts exercise a permissible discretion in the context of international law, within the written law of interpretation, in the context of municipal law, within an unwritten law of interpretation, there is some analogy, some comparison. Well, we will see with a number of exact and precise examples to understand these concepts better. Now let us see an actual example of strict interpretation. That's a real example. And to my mind, it's a very simple case, but it's a classic case in the sense I have always been teaching this case to my LLB students. Why? Because it's very common, the facts are very common. And the judgment has been written, with brilliance by Justice Vivian Bose wrote this judgment. It's one of the best. Vivian Bose was really class. Let me tell you the facts of this particular case. Obviously, slides cannot be made in order to be a reproduction of the whole case, whole judgment. Then we will have hundreds of slides of one case. So you have to limit it somewhere. Anyone who is aware of this case, if you are aware of this case, then you should assist the class, otherwise I will have to tell you. You see, the question was this. The question was the concept of possession. The statute was Essential Supplies Act. The provision for the issue was very simple. All the sellers who are selling cotton bales, in this particular case, they were a seller of cotton bales, supplier. And whatever supply you are making, you have to give a record to the government. How many bales and how much you have sold. In a particular case, or in this situation, when this issue came up, what happened was, a particular seller has sold certain cotton bales. Money had been received, but before the bales of cotton could be delivered to the buyer go down where the delivery had to be effected was not possible. Now, the agent of the seller had put those bales which were sold but not delivered at the godown of somebody whom the purchaser and the seller both knew. The seller was accused of giving a false information, because it was alleged that those bales which were not delivered to the purchaser but were delivered to at the godown of the agent were deemed in law to have never been sold, and therefore the information supplied by the seller was wrong, and therefore he should be liable and should be an imprisonment because of giving false information of sales. That was the issue. So the whole question was this, and it was in this context that Justice Vivian Bose made this observation. He said, in a penal statute of this kind, that is, this kind means Essential Supplies Act, it is our duty to interpret the words of ambiguous meaning. Words of ambiguous meaning, the possession of a del creditor agent. You know a del creditor agent? Who is a del creditor agent? You must be knowing the concept of agent. What does he do? He is an agent for the purposes of a transaction. That's it. You are paying for certain things, he is your agent. Then after half hour, somebody else is paying for something, he becomes agent. He is not an employee, he is an agent. Similarly, in this particular case, when the goods did not reach the godown of the purchaser, the godown of the del creditor agent was deemed in law to have purchased the goods on behalf of the purchaser. And therefore, the court said, if we do not consider this, we will send honest people to jail. And that is not the purpose of the law. So the whole question was how to interpret the possession of a del creditor agent. And the court interpreted it in favor of the accused, the Cotton Mill, saying that he was all right. There was no intention on his part to give a false information. He gave this information only after the goods left the godown of the seller. It is immaterial whether the goods reach the godown of the purchaser, because the information he gave only after the goods had left the godown of the seller. And whether or not the goods were delivered to the purchaser, the relevant was goods never returned back to the seller. So possession of goods once left for the seller never returned. So if you do not consider the possession of a del creditor agent, because the del creditor agent is not neither the seller nor the purchaser, what do? You would necessarily send the seller to jail. That is not the way in which a penal statute of this kind should be implemented. That is what the court has said. So court gave a meaning to the ambiguous word called possession of a del creditor agent. How do you decide? Because interested parties are to buyer and seller. Are you getting the point or not? It's a very simple thing. There is a buyer, there is a seller. Certain goods left, the sellers go down. Intended that they be delivered to the purchaser. Purchaser could not take the delivery. So the goods returned not back to the seller, but to the agent. Agents go down. So the question was, a good which is in the possession of the agent, whose possession? Possession of the buyer or the seller? The court did not say it. The court said it is not necessary for us. For us it is important that these goods did not return to the seller. And if the seller said that I have sold these goods, the seller gave this information correctly. There is no falsity. And that therefore gave the benefit of this interpretation in favor of the accused. This is how you do it. Because this is a bona fide transaction. Had the goods returned to the go down, and still the seller would have said, well, no, I have sold it, then the situation would have been different. So this is one case of strict interpretation. So in other words, strict in the sense, the court had the possibility of interpreting it in both ways. The court interpreted it in order to help the accused. Why? Because the court on facts found the accused, the mill, to be honest. It was not the intention of the Sexavia cotton mill, or it was not intended by the mill that the information should still be given of sale even if the goods have not been delivered. There was no intervention, there was no participation, there was no connivance by the seller. It was just a chance that the goods, the go down of the purchaser was closed. So, agent had this two options, suppliers had two options, the people, the truck which was taking those goods had two options, either to take it to the agent's go down, or to the go down of the seller. I mean, it is very simple. If you put a mail or put something, and it is not delivered to the address, you have two options. Either you take it back, or you put it to some agent, if the agent is known to be both buyer and the seller. The court said, the agent in this particular case, agent's possession was the possession of the purchaser, not of the seller. Therefore, the seller was not liable. And hence it was strict interpretation.
Sir?
Yes.
Sir, what about the provision of CPC which says that a judgment debtor can be imprisoned if he is not able to pay his debt? So, if that, it's a penal statute, so should it be interpreted in a remedial manner? Because CPC, you just now said that it's a remedial statute.
Yes.
So, should it be interpreted in a remedial, in a liberal manner or in a strict manner?
You see, the whole question is this, it is a remedial statute. The statute would remain remedial. There may be a penal provision in a remedial statute.
Yes. So, sir, how should it be interpreted?
So, it be interpreted on the facts and circumstances with very totally discretion. You see, for the issue to the court available in this particular case. Because I should tell you, it is a penal provision in a remedial statute. So the question is not of giving any liberal interpretation of the statute. The question is of giving a proper interpretation of the penal provision. Any provision that awards punishment is a penal provision. But that would not necessarily change the overwhelming nature of the statute which is remedial. So this is for the court. The court may say, well, you have to undergo an imprisonment. The court may say, well, give more time. The court may say, well, you do it in 3 weeks. After that, you have to undergo imprisonment. Most of the cases, let me tell you, my experience, whatever little that I know of from domestic law, my experience is this: in civil cases, the courts are very, very lenient, you see, in giving punishment. Even on the last day, the court is all like, we do it in 1 week. We will do it in 2 days. Otherwise, we will send you to jail. Then the fellow will do it. Who will not do it? You will do it in 2 hours to avoid going to jail. So, it actually serves him. So, courts are allowed in any case. What is the problem? We just give him last opportunity to do it tomorrow. And he will do it. And if you know that you are not able to do it, of course, you will go to jail tomorrow. So, what does it matter? On the date of hearing or the next day? 99% cases, you see, some very, very, very serious cases. Let me give you an instance where in a contempt case, very famous Vasudeva case of Karnataka, very famous case. There was a specific direction by the court. Then you do certain things by 30th of such and such or 20th of this. The order was addressed to Chief Secretary. The court did it after having seen several representations by the state government, several undertakings will do it in the proceedings. So you know there is a history. The matter was before the court. The government was saying, giving undertaking, we'll do it tomorrow. Then again the hearing, this again would not, we'll do it, give it 15 days, all I do 15 days. So it was delaying. And then came an order saying that you do it on this day. The chief secretary did not do even on that day. And then he went to jail. You try to understand. That is what I am saying. Reading cases will actually make you understand the law. In abstract, there is a limit. But actual experience comes like this. Now, how do you interpret this? It was a civil contempt, not a criminal contempt. But the whole issue is this. What did you do? It was not just first order. Had it been the first order, you would, I can tell you, no, never. I am not aware of any case where on the very first order, you see the court will send you to jail. It's all right. Fine. You have missed this deadline, okay. Do it in 15 days. There are 50% chances that you will still escape on second day. If you are a judge, just apply your common sense. How do you feel? Which means that you have no respect for the court. You come here and every time you say, I couldn't do it. This happened. If you give these kinds of undertakings, the manner in which the court has told it, I should tell you a very famous case, Narang case. The court said, when you give an undertaking to the court and you do not abide by it, this is a fraud on the judiciary. This is a particular word has been used by the court. 2000 case, 6 years. It is a fraud on the judiciary. So they'll send you to jail. Otherwise, no. So certainly a provision in a remedial statute like CPC, which says, if you do not implement this, then go to jail for judgment letter, then obviously this is a penal provision. But this is not done just on a very first take. No, the court would certainly give you one opportunity. One opportunity is unless the judge is exceptional. Judge is exceptional, then only on the first deadline being missed, he will go to jail. But 99.9% you won't go to jail. Let us take the example of a liberal interpretation. Again, a very simple example, and I should give you a much simpler example, perhaps the simplest example that I give to students. You see, you know that delay defeats justice. I can give you several examples out of personal experience as a litigant before Indian courts. But that is not the occasion, and the class certainly is not that I should be allowed to do so. But of course, if you have questions, then I will with pleasure respond. But what I am saying is this: I have personal experience how delay defeats justice. But sometimes some flexibility in remedial law ensures justice. I don't call it delay because delay has a negative connotation, but I am saying some flexibility. Now, having seen that delay, there are several ways of delaying things. Litigants know hundreds of ways to delay. Believe me, hundreds. And sometimes atrocious ways of delaying justice. When I say atrocious, I should definitely substantiate my very strong statement. What I call is atrocious is this. I have seen so learned an advocate as Ram Jethmalani coming to the court, Delhi High Court, to a single judge, absolutely unprepared of the case, without mincing any words, saying it to the judge, Your Lordship, I do not have the time to read the file. But I should tell you a story from a Shakespeare's novel. and he started saying it. For 10 minutes, he told about Shakespeare. And then he stopped saying, Your Lordship, I should be obliged if you give another date so that I will continue with my argument. Atrocious in two ways. First, that a lawyer has the audacity to come to a court without being prepared. And second, for the court, if he was not prepared, why did the judge listen? William Shakespeare. You know the cost of listening for 10 minutes William Shakespeare? Do you know the cost? You are not aware. Let me give you the statistics. Official statistics of the Delhi High Court. 1 minute of judicial proceedings of Delhi High Court in 2002 costed to Delhi High Court 4,700 rupees. Multiplied by 10. 2002 prices. Delhi High Court is run by the public money, taxpayers' money, your money and my money. Now, had he been any other lawyer other than Ram Jethmalani, you know what would have happened? He would have been thrashed by the judge. I'm going to dismiss your case. Get out. Argue today, or I dismiss it. This is called atrocious. So when you can't defend yourself, how can you defend it? You have no other option but to hire a celebrity lawyer. Because only, if you have nonsense to say, if you have nothing to say, you have no way to defend yourself. Only a big lawyer can defend. Not by argument, because you have no arguments. A bad argument in the mouth of a good advocate will remain a bad argument. But it is basically the manner in which, other than judicial ways, sometimes courts allow court proceedings to be conducted. That is why you are safe. Absolutely not otherwise. You have seen in Mr. Jayalalitha's case, if you see the verbatim records of the proceedings, you will be very much surprised. I have only one question to tell you. This country and many other countries of South Asia are ruled by rule of law. What about other litigants who also have to prepare an appeal and they still are behind the bars? What about the rights of those? Put it more bluntly, what about those litigants who cannot, could not and will never be able to hire a filing element? You know the cost of hiring him? You don't know. It may range from 50 lakhs to crores, several. Ram Jethmalani admitted himself admitted, I charge 3 crores. Why? Because I charge only for 1.1% lawyer, 1% litigants.
Most of the time he's saying that I'm doing problem.
So this is basically I gave you this because this is a very spicy thing and in order to understand. If I should give you some technical ways of dealing justice, that is heavy stuff for you. These are lighter ways in which I can learn. This is a daily occurrence. Daily. This scene goes on in the judiciary daily. Sometimes such an atrocious things which you can't believe it. Excuses which I have never seen even my students are giving it to because I don't entertain those excuses from the students. If they come late to the class, this is an optional class. The compulsory class I don't allow students. In my evening classes, the students are not allowed once I enter the class. And I have standard argument to them. They say we are late in traffic jam. I said, do you know when I start my day? 4 o'clock in the morning I start traveling. 250 kilometers I travel for one class. And I'm never late. You tell me who travels more than 250 kilometers. How can you believe it? So the point is this, atrocious arguments in terms of delay. I have seen judges entertaining arguments such as, sir, I could not get the copy of the petition. I would like you to react to this. Can anybody react to this if you are a judge? Suppose you are a judge and I am an advocate of one party. And I am saying, sir, your lordship, I did not give a copy of his petition. So how can I argue? How do you react if you are a judge?
It depends on the face
Any other reaction? This is not a spicy thing. This is not Shakespeare. This is a technical point.
I will tell him to leave that and wait.
No. It is a very precise and technical point. Very precise. You know the answer? The answer is no petition can be filed as a matter of rule without having been served a copy on the other advocate. If the copy is before the judge can say, if the copy is with me, you are lying. There are only two possibilities. Either you are lying or the person in the registry is lying, has falsely stated that copy has been served. The action must be taken either against the lawyer or against the person in the judiciary. This is a rule. This is a rule, and I need not read CPC. I have done it in my life more than 50 times. There are certain things I know by my practical experience. You have to serve a copy to the opposite party before the registry is going to take it. In other words, the copy will go to the judge after it has reached the opposite party. This is the rule. And the lawyer says, sir, I did not get the copy. So you give me another date. And the judge look at it. Instead of probing it, gives him 6 months date. You know what is the conclusion? The conclusion is there is a complicity between the lawyer and the judge. He said, but you just say it, I'll give you. 6 months date. And I should tell you the facts. I know it. Because there are certain things I will not name the case and litigants. The person for whom the lawyer was appearing is retiring in the month of February 2015. And the date is January 2015. So he has to just stretch one more month and the matter becomes infructuous. This is how justice is being delayed. Justice can't be delayed unless there is a collusion between lawyers and judges. Can there be a simpler thing like this? Sir, I did not get the copy. Just think about it. And judge has copy in front of him. My question to you is this. It is like this. You see, that teacher should say, or somebody should say, well sir, I did not get the copy to write the examination, and the copy is before the teacher. If the copy is with me, the written transcript of a student comes to the evaluator only after it had been given to the student. It simply can't come as a matter of logic. You are simply saying, sir, they did not allow me to write, otherwise I knew every question. So, these are atrocities. Sometimes you see in the judicial process. So, in other words, let us come back to this point again. This was in order to mitigate this, to give relief to the litigants. Indian Parliament, amended the CPC and made it obligatory that the respondent must file his reply within 90 days. You can't say I did not get copy and all these kind of nonsense. Now, just as in this case, there is a fellow who had a nexus. There may be a very genuine person who is not able to file a reply in 90 days. I should tell you a genuine person. How? There is a person who is a tea vendor, who is a pan vendor. A person who is simply, a pauper. He got a copy of a notice from High Court of petition. First of all, he would not understand what it is. He'll have to find somebody to explain this is what. Then, this is the legal thing, it has to be replied. Then he does not merely need a person knowing, reading English, but must be qualified enough to reply. Finding a lawyer means entailing expenses. then he has to make a choice what to do. Whether I should fill up my fee of my 2 kids of next month's school fee or find a lawyer. So there may be 100 reasons for a genuine person. It is quite possible that a genuine person may not be able to file a reply in 90 days. This was precisely the issue in this Rani Kusum versus Kanchan Devi case. The reply was not being able to file for bona fide reasons. The other party said, Your Lordship, you can't increase more than 90 days. And here you have another litigant. The example that I gave you that we did not get a copy, the same lawyer says, you can't give more than 90 days. It is justice delayed, justice denied. 90 days is over. And 90 days were over just one day before the case was filed. 91st day he filed this case. Look at the other side. Then in that case, the judge said, Justice Dr. Arijit Pasayat said, a procedural law should not ordinarily be construed as mandatory. Because it is true that justice delayed is justice denied, but it is also true that justice hurried is justice buried. If 90 days is a delay, 95 days will not make it a much worse delay. It is quite possible that if you allow 5 days, maybe justice is done. So this is sometimes, this is the case. So it is a remedial law, even if the law says 90 days, and the word shall has been used, mandatory is used. But the judge is saying true, as a matter of English, it is mandatory. If you read the expression, this is compulsory, this is mandatorily worded as a matter of English language. But since this mandatory language appears in a law which is remedial, and remedial law is never considered as mandatory. So that is what the judge said. So a person was allowed to file a reply even after 90 days on the ground that the law was remedial, it was not considered to be mandatory. So this is what was the understanding of the court. If you want to take a break, as far as the lecture is concerned, I think this is the point where you can take the break, because the domestic law and then we start with international law, and then if we take a break and we will lose the continuity. I think this is the appropriate time to take a break, but I request you to take a quick break because I have a lecture at 6 o'clock, so I will be leaving exact time. Please. To these kinds of, appellations on the basis of the nature of the statute of treaties. In other words, Vienna Convention does not describe treaties' nature. It tells you about treaties' interpretation. So that is the first thing that you notice. And with that, you can further make a deduction that in the written law on interpretation in the context of Vienna Convention and international law, treaties have not been differentiated. Certainly not with appellations such as restrictive or effective interpretation. But that is not to say that international bodies have not given restrictive or effective interpretation. It is true that they have done so without giving a reference, without characterizing the nature of treaties. There is a fundamental difference between the enacted law on the municipal plane and the enacted law, as it were, on the international plane, that is treaties. The first difference you find is the lawgivers, I am using very loose terminology in the wordings of Bentham. The lawgivers on the municipal plane are not the only subjects of law. They are also the subjects of law and mostly in a very municipal minority. Immediate example is Indian Parliament meets roughly 550 people. But the law that is applicable, criminal law, any other law that they make, is applicable to entire India. So if you make a percentage of Indian population in Indian Parliament, you have to 0.00001. Now immediately compare international law. The law givers themselves are the subjects. It is exactly the reverse. In 99% cases, only they are the subjects. That is the fundamental difference. Second difference, which is a recurrent description, is that they do not have a written law. In most cases of interpretation, on the international plane, they have almost always a written law. And with the Vienna Convention's status being customary international law, the distinction between parties and non-parties is also not significant. You have seen in that black money case, you see before Indian Supreme Court also made this particular point, saying that, well, even if India is not a party to it, but quite correctly, that many of the provisions of Vienna Convention, including of this Article 31(2), are parts of customary international. So that is another important point, that even in those situations, and specifically on interpretation, where a country is not a party to Vienna Convention, rules of Vienna Conventions on interpretation is still applicable to non-parties to Vienna Convention as customary international law. These are the fundamental differences. Now, let us take one example of restrictive interpretation on the international plane. Here was this very famous case of SS Wimbledon. As a student of international law, it is very difficult for me, to believe that you are not aware of this case. The cases that I have, selected are really the classic cases. I spend a lot of time, in finding which cases are discussed. Could you tell me what had happened in this case?
Was a sheep.
Yes.
And someone came looking sheep, and she leaped from the sheep to the France. A lot of times I heard this case. The famous case in international law. This make issue of this.
Yes, whatever you have said is correct, but a lot more is to be said about this. As a bare minimum. Any other person who may have heard of this case? You see, the context was very simple. The context was the end of the First World War. The end of the First World War. And the First World War ended most significantly as a matter of international law with the signing of the Treaty of Versailles, 1919. Now, as a result of that, you know that what had happened to Germany. Germany was declared the culprit, and it was treated given all punitive consequences with all kinds of liabilities. Liabilities in terms of treaty relations, liabilities in terms of movement, liabilities in terms of, foregoing of certain parts of territory. What? I think territory itself, the loss of territory is the biggest that can be inflicted on a sovereign state. Now, Germany was asked by the terms of Article 380 of the Treaty of Versailles to remain a neutral. Neutral in the sense that not taking sides in a situation of any war between any two countries. Now, in this particular instance, the question of Germany's neutrality came into question in the context of war between Poland and Russia. Now, the question before the court was whether Germany had the right to regulate access to Kiel Canal or not. First. Two, what were the plain terms of the Article 380 of the Treaty of Versailles? The point is very simple. International Court of Justice, Permanent Court of International Justice, in this very case, said it in a different context, but that is very important for you to understand the principle, and that I quote from this case. The court said, every international agreement produces certain limitations on the sovereignty of a state because it requires that a state to conduct itself in accordance with the provisions of that agreement. But the right to enter into international agreements is nothing but an attribute of state sovereignty. So in the first clause, the court is saying that if you sign a treaty, it certainly limits your sovereignty. It is a measure of derogation from your sovereignty. But then in the second clause, it emphasizes that the right to sign a treaty is an attribute of state sovereignty. In other words, these are two things. If you are sovereign, only then you are able to sign a treaty. But once you sign a treaty, your sovereignty, to the extent that you have signed off by the treaty, is gone. That is basically the crux behind, that is the principle, and this is the actual reproduction, this is the actual consequence, this is an observation on facts, and what I said you is an observation on, and as a matter of principle, and that is it. So, in the first clause that you see, the court is saying, as a sovereign state, we should not interpret any treaty which restricts a state's sovereignty. That is a matter of principle. But if there is a clause in a treaty that restricts, then what should we do? What should we do? Should we give effect to that clause, plain meaning, or should we bother about what will be the consequence of giving effect to the plain meaning on the sovereignty of a state? These two situations are there. The court is saying, as a matter of principle, we should not interpret a treaty which should be a diminution on the sovereignty of a state. But again, as a matter of principle. But if, as a matter of fact, a country has signed a treaty, the effect of which is to produce limitations on its sovereignty, shouldn't we give effect to that particular provision? Still further, if we don't give effect to the provision of the treaty, would not the treaty be violated by the interpreter? That is the issue. So court is saying in this case, as a matter of principle, we should not, by interpretation, limit the sovereignty of a state. But if the sovereignty, limitation on the sovereignty is the inevitable consequence of the plain meaning of the treaty, let it be. So restrictive interpretation, as a matter of principle, is not a license to rewrite, to ignore the plain meaning of a text, even if the text produces limitations on sovereignty of a state. This is what it's saying. So I repeat it, this is a very important case because in this case, you get a very clear picture of the principle, and you also get the limitation of the principle in terms of the plain meaning of the text. In other words, if the plain meaning says that there will be restrictions on sovereignty, the court must give effect to plain meaning. But if the plain meaning produces two consequences, one is limitations and another is non-limitations, then obviously is a choice. Then the court must choose which produces no limitations or less limitations. That is the whole question. The point is this. Again, get back to Vienna Convention. We started with the general rule, and general rule said you have to give ordinary meaning. If the ordinary meaning says, then you have to restrict your sovereignty. What is bad about it? You have signed your treaty. I am not restricting your sovereignty. I am merely reading the treaty. You have signed it. So I am basically the mouth. I am basically the speaker. But I am simply reading what you have said. But yes, if the meaning is equivocal, if the meaning, ordinary meaning, is vague, it may be read in two ways. One way produces consequences, negative consequences, limitation on sovereignty. Another way produces no limitations on sovereignty. Then, of course, is a choice on the basis of this principle. The court will produce a consequence which produces no choice or a lesser, no limitation or a lesser limitation. This is what the court is saying. In nutshell, restrictive interpretation will not allow you to violate, to ignore the plain meaning of the terms of a treaty. If there is only one meaning of a text, and that one meaning means limitations on sovereignty, it will be allowed. It must be the only interpretation. This is what the court said. So this is a very good, case on the principle of restrictive interpretation as a matter of principle, and it is also a very good case, even if this came in 1923, in other words, 36 years before, 46 years before the Vienna Convention. The importance of the plain meaning is equally highlighted 46 years before by the International Court. Again, another example. 1950. The position of the law 19 years before the Vienna Convention. Second example of restrictive interpretation. Do you know the facts of this case? Have you heard of this case? It is a very simple case as far as the point on which we have to recall it. You see, in normal cases, when an arbitration is prescribed, the general terms is this, that one arbitrator is appointed by each party, and the third arbitrator is going to be appointed by the arbitrators appointed by parties. Now, the issue in this case was that these countries, they were saying they have not appointed arbitrators. Now, and the treaty had called for appointment of arbitrators. It was alleged on behalf of the developed countries, Western countries, that you must appoint an arbitrator because the treaty allows for arbitration. The court said, even if no arbitration is held, let it be the case. But we will not be able to appoint a third arbitrators unless first two arbitrators have been appointed, because that is the provision of the treaty. So the principle of effectiveness. Effectiveness means, as a matter of understanding in the law of interpretation, then you have to give effect to each provision of the treaty. But the whole question is this: if prior fulfillment of two appointments of arbitrators is a requirement for the appointment of the third arbitrators, how can you appoint the third arbitrator? And if you are not able to appoint the third arbitrator, are you giving an interpretation to a treaty which is ineffective? The court said no. The court said that will be contrary to letter and spirit of the treaty. I mean, just think of a situation. Let us say you are two groups, one this side and this side. You have a dispute, you have agreed that whenever we have a dispute, one arbitrator will be appointed by us and third arbitrator will be appointed by both the arbitrators. These people have not appointed an arbitrator. Now, what would be a situation? That you appoint one arbitrator and I appoint second arbitrator, and these two arbitrators will arbitrate the matter. Is it possible? It is simply not possible. Because the appointment of third arbitrators, the conditions for appointments of third arbitrators have not been fulfilled. If the treaty that gave you the opportunity, the possibility of arbitration have also limited the manner in which the arbitrator is to be conducted. The court said, we can't do this. The court said, in the absence of the appointment of two arbitrators by two groups of states, third arbitrators may not be appointed. And this, we cannot employ the principle of effectiveness contrary to the letter and spirit. Again, as in the Wimbledon's case, you can see the importance of the letter of the law. In other words, whether it is restrictive or whether it is effective, it may not violate the letter of the law. If the letter of the law is neither vague nor ambiguous, tells you only one meaning, you have to give meaning to it. And if the meaning is so clear, if the letter is so clear that the third arbitrator is appointed only after two arbitrators have been appointed by restrictive parties and only one party has appointed an arbitrator, the clear effect is then the third arbitrator may not be appointed. That is the end of the matter. Because there is no ambiguity about it. The treaty did not say that arbitrators must be appointed. For instance, sometimes, let me give you some illustration, some possibilities of, some analogy with the Indian arbitration. Sometimes parties are not able to appoint arbitrators because they know they want to dilate the matter, delay it. Then there is a possibility that one party should approach the Supreme Court. And in many cases, the Supreme Court appoints the arbitrator. There was no such provision there. The treaty was very clear. First two arbitrators must be appointed by parties. So the treaty did not allow for possibility of arbitration in the absence of appointments of arbitrators by each group. No arbitration. So this is basically a very good case again, and the importance is of the letter of the law. Restrictive interpretation, the third example. Now we move on to another law which is post Vienna Convention. So we have two examples before Vienna Convention came into being. Now this example is after the Vienna Convention. And this example you can see, you have this example of a case that was between United States and European communities on the one hand and Canada and European communities on the other hand, on the same set of facts. So both these reports, both these findings are absolutely same as far as matters of law is concerned. Now, very quickly, you may not have read this WTO law, the provision on sanitary and phytosanitary measures. Very quickly, the limitation of time that I have, you see, WTO is a set of rules. Member states are bound to follow these rules. Some of these rules, example, SPS agreement, allows you a degree of flexibility in complying with the rules. What it says? It says that you may adopt any measure in order to protect human health, plant life, animal health, if you conform to international standards. So your deviation from international standards must be based on international standards. This is what it says. United States said, Canada said that based on means compliance with international standards. European community said no. Compliance with, conformity with is a much stronger language. Based on means, then whatever you are doing, it has some basis in international standard. It doesn't say, it is like this. For instance, a provision saying that students are free to have a cup of coffee during break. This is a provision. What does it mean? Nowhere does it say that a student must have to have a decaffeinated coffee during break. Nowhere does it say the student must have to have a coffee with 1 teaspoonful of sugar. Nowhere does it say the students are prevented from having a cup of coffee without sugar. Nowhere does it say that students are prevented from having a coffee without milk. That is a difference. Mere fact that the students are allowed to have a cup of coffee, it doesn't go with it. Then students are required to have a coffee with a particular type. So in other words, coffee and ingredients of coffee. Similarly, any standards that a country adopts on the basis of international standards and close compliance with international, standards. That is it. A degree of flexibility. So this is what the WTO appellate body is saying. Restrictive interpretation means, here is a possibility. The two possibility is whether you are complying with coffee or you are not complying with coffee. This is the whole issue. As long as the example, a very simple example that I gave, as long as you are having a coffee, you are complying with it. Whether you are complying with milk, without milk, decaffeinated, caffeinated, all these are allowed. You as a state are entitled to this flexibility because this is not stated in the treaty. And if it is not stated in the treaty, by way of interpretation, we can't restrict the freedoms of the states to adopt these measures. This is what the court said in this case. Then you have effective interpretation. Example, you had this rite of passage case, very famous case between Portugal and India concerning Goa. Now, this case, went to international court and by Portugal, taken up by Portugal, and India had to respond. India wasn't happy that Portugal took it to international court. So, in the first instance, India contested jurisdiction of ICJ. So, ICJ said on this that it is a rule of interpretation that a text emanating from a government must in principle be interpreted as producing and intended to produce effects in accordance with existing law and not in violation of it. International Court of Justice was saying, when a country files an objection or another country responds to it, both these objections and responses have to be interpreted, given effect to in the light of the existing law of both these countries. So in other words, we cannot read the provisions or statements by a country's position before international court in a violation of the existing law. And we have to produce effects. We have to give meaning to the objections. We can't say that these objections are without meaning. Whether or not an objection is upheld or whether or not an objection is rejected. Many of India's objections were rejected. But all these were rejected on the basis of the law that was existing. So in this particular case, the court said we have to give effect to it. We can't ignore it. Once you have filed an objection, objection is going to be interpreted. Objection is going to be evaluated. It is like this. You have written an answer. Can a teacher say, well, I can't design this answer because the law is not clear to me. This answer sheet should come to me next year. So what will happen to you? Whether you remain in LLM first semester or second semester? You have to, it has to be decided. No, try and understand. Please try and understand what I am saying. it is quite possible that teacher decides incorrectly. For that there is a procedure. The answer script may be given to third exam. But the situation is more dangerous when you say that I can't decide it. Because there are few appeals filed and this question is relating to that appeal. So let that appeal be first disposed of and then I will decide this. You can't do this. The same thing is this. A country has filed its objection. Whatever the law that is existing before the court, you decide it, whether you accept it or you reject it. You can't say that we will not decide it. No. That is effective interpretation. Another example. In this particular case, the example concerned is another WTO case, and this is a post-Vienna Convention. In this particular case, as you might be aware, there was a situation where United States was distinguishing between the gasoline, crude gasoline coming from Venezuela for exports for consumption in the United States, and also the gasoline which the United States was producing in the United States, and was saying that the gasoline that it was producing produced only limited effects on clean air, and the gasoline produced by Venezuela was very harmful as far as United States was concerned, and because the gasoline production was after a particular date, and that date was critical because the United States had adopted a law saying that any gasoline imported after that particular date will be subject to a particular processing. Now, WTO said, what is the nexus between a particular date and the objective of cleaning your air? WTO said this is simply arbitrary. It is not justified. Now, the WTO appellate body in this particular made a very good observation. This observation is very important. Because it says one of the corollaries of the general rule of interpretation, here it is specifically referring to Vienna Convention, is that interpretation must give meaning and effect to all the terms of treaty. In other words, one way of understanding effective interpretation is that, let us say, if there is in a clause 10 words, you can't give effect to 9 words and ignore 1 word. The court is saying you have to give effect to all 10. You can't presume of any particular word to be a surplusage. Because if a particular word has been used in a treaty, then it is your obligation to give effect to all the words. This is the important. And now in this particular case, just to complete the whole point of in this particular case, you have in this particular case Article 20 in question of GATT, XX, that is all Roman in GATT articles, 3 points in the statute, and 1 point in Article 20, paragraph G. So you have to give effect to paragraph G. You also have to give effect to 3 operational procedural requirements. And that is how you will give effective interpretation. Now there are some conclusions which follow. One is that these are basically characterizations, whether you call it restrictive or effective, synonymous with strict and liberal interpretation on domestic plane, and they are relative to the nature of interpretive text typically in the common law legal systems. So strict and liberal, these kinds of appellations you do not find either in international law or in civil law. These are typically to be found in common law legal systems. Second is, Vienna Convention does not state is restrictive or effective interpretation. The third and final conclusion is that restrictive and effective interpretation are a manifestation of an interpretive choice considered permissible. 2 choices. One for deviating from the ordinary plain meaning of the interpreting text, and this first sub-conclusion is most common case in the domestic law. We have seen the example of possession, Sexelia Cotton Mills case, and second in the case of deviating from 90 days prescription in the remedial law. But on the international plane, for not deviating from the ordinary and plain meaning, You have seen in the Wimbledon case, the court did not deviate from the plane. You have seen in the peace treaties case, court did not appoint the third arbitrator because the plain meaning did not allow for the appointment of the third one in the absence of appointments of two arbitrators. So this is basically these two diametrically opposite results you find on the basis of this, and it is done. The main choice that you find is basically between the municipal and the legal and the international legal system. And in this particular case, what you can say is the degree of discretion that you find to deviate from the text is much higher in the municipal than in the international. In international law, the courts are highly circumspect for several reasons. One is that they are basically interpreting between the lawmakers. Litigants are lawmakers on the international plane. On the domestic plane, litigants are not lawmakers. Most of the time. That is a distinction. And second is, again, that is a running theme, then there is no written law of interpretation on the municipal. It is a judgment. So yesterday it was judgment, today it is judgment, and tomorrow it is judgment. Yesterday the judges said it was law. They said one day, then you can't amend fundamental rights, it was law for some time. One day they said it can be amended, it became a law. Then some other day you will say something, that's a law, because that is your authority in the Constitution. This is not the case on the international plane. Why? Because there is a written law of it. So that is how you can see. Here you can see very closely the dynamics, coming at certain level, you can see the contrast. This interpreter choice for deviating on the municipal plane and not deviating on international. Anyways, thank you. If you have quick questions, you are most welcome. You can ask a quick question even when I am winding up.
Thank you.
Welcome. You can't delete this file.